Hello, everybody.
Hello.
All right. Welcome. Who all do we have? I'm getting down to my.
You're good. Let's see if I can hear you. Hello, everybody. Hi, Ben.
Good afternoon.
Hey. Hello.
Hey, Patricia.
Patricia,
Welcome to the
welcome
team.
to your first meeting.
Thank you. Thank you. I'm excited and scared at the same time.
Talking, I can't hear you.
We
You
don't
should
bite. They invite every once in a while, but it doesn't hurt.
There we go.
Oh,
Okay, so we have
yes.
of the voting board members, we have Eric and Patricia and Christy and Mark. And
Hey, Van, it's Cara. I'm here.
Oh, thank you, Cara.
Cara.
Yes.
yes, thank you. And there's Cara.
You want to call roll, Mr. Chairman?
Yeah, we may need to because there's a lot of folks on here and I'm just trying to go through it and then people may. Yeah, would you mind?
No, that's fine. Cara,
I'm here.
okay. Mark Wilson,
Here.
Christines,
Here?
Eric McDaniel,
Here.
Tommy Majors. Tommy, can you unmute or are you there? We know you're there, but I don't know if you're. It's a new board member, Mr. Majors. Let me see.
Oh, yeah. Do I see? I see Gene Majors, but he's trying to find, that may be Tommy. Yeah, Tommy, you're on mute. I see you, but I can't hear you. You're still on mute.
I'm working on it.
You should be able to, let's see. On the bottom, look on your bottom left, Tommy, you'll see a mute button at the very, very bottom left of your screen. It says mute, and it's probably got a line through it now.
I've asked him to unmute.
Yeah. So, Van, we have him down while he works on that. If you'll continue with the roll, please.
Yes, I think I've unmuted everybody, but I don't know if that's true.
No, it may be on, I think it's on his side.
Okay, Patricia Blick.
Here.
We have three no shows at this point, and that's Dexter Doring and Pat Hayes and Sam Kaufman.
Okay, but at least we know we have a quorum. This is good. So if we have, Van, that means if we have three, oh wait, you said no shows. Did they indicate that they would not be attending?
Mr. Kaufman will not. Mr. Doring is a possible, and no comment from Mr. Hayes.
Okay.
Can you hear me now?
Yes,
Yes.
sir. Mr.
All right.
Mr. Majors.
I'm Tommy Majors. Hi, Patricia.
Hi there.
Well, congratulations.
Hey, that's a milestone.
Sometimes the harder we work to solve something, the better we remember them next
You
time.
get- I like that.
I remember
That's
that back
great.
in the coding days in college. Okay, Van, so we've got a few items here. Let's be sure to, let's go ahead and jump into the
Okay.
agenda meeting, please.
All right, the first item on the agenda today will be, of course, approval of the minutes, but the second will be new business, and that's the Shaheed family exclusion. The applicant has provided everything necessary in order for us to recommend approval is filed. There's no issues on this family exclusion. It's a one lot family exclusion.
And if Van,
On 145th Street.
yeah, you may want to back me up a little bit if I leave anything out there, but Patricia and Tommy, family exclusions are called exclusions because they get to bypass a lot of the ordinary requirements for these requests, because it's actually passing down from one generation to the other, or actually not necessarily that advanced, from one family member to another.
Right. The designated family members as designated by the ordinance, which is father to son and grandson and that sort of sister, brother, that sort of immediate family.
Right. Okay, Van.
Okay, so and this lot is on 145th Street in case somebody wants. The second item of business is the Stall Cup Moreland addition. It's a one lot final plat. That's sorry, 2-lot final plat. Let me show you what, see what you so you can see what we're talking about here. That was the 145th Street family exclusion. And this is the Stall Cup property. And you can see.
Oh, we're still on the Shaheed.
Keep going. Here we go.
There we go.
There we go. Yes. Whoops, wait.
There's a lag.
Okay, there's a little lag time. Anyway, so
Wait, now we're on Thomas. I think we need to go back about 3 slides.
yeah, we need to go back to the
A couple more, I think.
here it is. That's it.
That's it.
This is the 2-lot. This is the 2-lot final plat. And the bottom line to this story is these lots exist. They're just adjusting the common lot line between the Curtis Thomas lot on the left or the west side and the Moreland tract on the east side there. So they're adding basically 30 feet to the Moreland tract.
Pardon me. Van, why I'm lost because I was waiting for you to pull up Stall Cup Moreland, and this is Thomas Estate.
It's
Am- What am I missing something?
Wait a second.
That's the same thing.
This should say.
This is the Stall. It's mislabeled. It shows Thomas Estates, but it is the Stall Cup tract.
Okay,
The one that's on the screen is what we're talking about.
so this is the Stall Cup Moreland. tract
Yes, it's
1R.
mislabeled at the top. Yes, that's right.
Okay, all right, thank you.
You're welcome. Sorry for the confusion, but it's pretty much straight ahead. There's not much to that.
Okay,
Biggest deal was them getting together and being able to come to terms on the 30 feet. The next item is the
now wait a minute, Van, I apologize.
what?
I was lost. So what did you say about now that I know which one we're talking about and other board members, the 30, there were no, they seem to have met all of the requirements. What was it that you said about the 30 feet?
Oh, I'm just saying the biggest hurdle to this was them agreeing on their 30 feet. That's what I'm saying, in order to do the plat. There's no
Okay.
issues. There are no issues.
Okay,
How
yeah,
about that?
okay.
All right, let me, I got some people trying to get in here. Let's see what we got here. Oh, that's, okay. There we go. All right, we're admitting some people here. That should be it. Okay, now, next item will be, say it will be, moves. There we go. That was the one that we just. All right, the next item is the item number 3, which is the PBGH, which is, it's a 1-lot plat, as you see at the corner of Batesville Pike and Jacksonville Conway Road. And it's actually a Dollar General store that the staff is reviewing on the site plan, but this is a 1-lot plat that have created to, it's actually a reconfirmation of their existing plat, but it's to dedicate the right of way for the additional right of way for Jacksonville, Conway, and Batesville Pike. And as far as any issues on the plat itself, the only thing that we would have is that they need to provide us with a plat that shows a surveyor's seal and signature, and that they'll need to provide the construction or inspection for, because they're actually going to build, they're going to widen both roads on their frontages to provide for the pedestrian circulation routes along the roads. And so they'll need to have inspections when they do the improvements by our inspection department. And they'll also be required to get a driveway permit. These are all standard functions of, but we wanted to iterate those issues. So, but its approval is filed, subject to those things. If there's no questions,
And
we're going
under the staff comments, show state plane coordinates.
Those have all been taken
that's been taken care of. And what those are, or it's just another, it's a survey marker in addition to the standard meets and bounds. Anyway, so yeah, that's just it's a more accurate designation than just the northeast corner of section 12 or whatever it is. They have that on there as well, but they also have to do state plane recordings ordinance.
Okay, so the under staff comments, I mean, you did review the additional staff comments, but under
Correct.
staff comments, those 5 items have all been taken care of?
Yes,
Okay,
the ones that I mentioned at the bottom there.
the additional staff comments.
Right.
Okay.
Right.
So those, just for everybody's purpose, so the staff comments, those have been taken care of since these documents were sent to the board.
That is correct.
Okay.
And so there are changes from the time we get things mailed out, because we have to do it so soon, and
Right.
the time we actually get to the public hearing. So when we mention the things, those are the things basically that are left. That's
Okay.
it. All right. So we're on to item 4, which is Waterview Estates. As you can see, there's 3 lots in it. There should be. There they are. They're kind of separated out there, but these are all lots that are, they're all, I can't reply. These are all been approved preliminarily, but these are the final plats of these 3 lots within these phases. And as far, the staff has received everything we need, and there's nothing left outstanding. Our recommendation is approval is filed on these lots.
I'm not sure how I got on mute, sorry. So that's all the new business.
You can
Were
see where they
there
are
any-
on the subdivision.
Yeah, oh, yeah, that's good, okay.
The
All
other,
right.
okay,
Yeah, and then we have the next item, which is the proposed planning board and the Board of Zoning Adjustment bylaw amendments. And we did, for everybody's, and especially Patricia and Tommy, we, in changes to the bylaws, we've had discussions about these changes. And then out of those discussions came a written form that we did a written version of the changes, and we did review these and read them last meeting. That's per the bylaw requirements. Any changes have to be read in one meeting and then subsequently voted at the next regular meeting. So that's where we are. We are at this, and Van, let's see. So that means actually that 2 of the 6 board members that will be voting today may not have seen these. So we do have a few minutes left. I think it might be beneficial to run through these real quick for Patricia and Tommy, since we're asking them to vote on it today. I see you have the planning board bylaw amendments up.
Yes.
So I can take a stab at it.
Sure.
There are a lot of changes in here that we're just cleaning up the document, removing, for example, or placing parentheses where there should have been, and so forth. The first material change that is being shown under Article 2A, and we're saying that a board member may be reappointed by the county judge for another 4 years after the completion of the member's first 4-year term. Any member who is absent for 4 or more, and the previous version said consecutive regular or special meetings, except in case of illness or extraordinary circumstances, shall be considered to have tendered her resignation pending the vote of acceptance by the board. The change there was to say, instead of that being triggered on the a member who is absent for 4 or more consecutive regular or special meetings, it is 4 or more regular or special meetings during a calendar year with the same exceptions. Any questions about that, Patricia or Tommy?
Yes, sir. More regular meetings, more than 4 in a 12-month period, or 12 from January to January,
Calendar year.
calendar years.
Yeah, it says here, just to be clear, during a calendar year. That's right.
Okay.
I know this isn't part of the change, but I was just kind of curious about what extraordinary circumstances are. I mean, I know we have some folks who aren't here with us today. Is that considered an excused absence? You know, for example, they're on travel or tied up with another commitment or something like that.
Yeah, we don't have a clearly defined definition of extraordinary circumstances. Fortunately, it's not come up, Patricia.
Okay.
I would hope that it would not.
Right.
But to be honest, we, in the past year and a half, we have had issues getting a quorum. So we felt like this was a good next step. I hope that we don't have to go to the next step of defining what extraordinary circumstances are.
Okay. Thank you.
Van, that next is just reelected to reelected. If you'll advance to the next screen.
Oh, hold on there. Issue. There we go.
These are, as a board on there or
All
not.
right.
Yeah, these are not material.
There you
Here
go.
we go. So, but I'm sorry. Oh no, I've got it right here.
That
So this is Article 5A, regular meetings, 2A3, and this says, it did read, under no circumstances shall the number of board members attending the meeting by electronic means exceed the number of board members physically present, unless the Pulaski County Judge issues an executive order canceling regularly scheduled public meetings due to public health concerns or for other unforeseen emergencies. So when the pandemic hit, obviously this became more important piece of our bylaws. And we consulted with the county attorney on this as well. We wanted to clarify that. And so the resulting, because there were some members that, myself actually included, that were on the fence about whether it was time for them to go back to public meetings in person. And so we didn't want the business of the Planning Commission to be impacted negatively due to the pandemic, simply because we couldn't obtain a quorum. So we changed this verbiage to say, a minimum of 3 board members must be physically present at all board meetings, unless the Pulaski County Judge or the governor of Arkansas issues the executive order canceling regularly scheduled public meetings due to public health concerns or for other unforeseen emergency. And my understanding is the county judge did extend that. He assured us that that was his intent. And so we are indeed meeting by Zoom today, and that allows us to obtain a quorum. Any questions there, Patricia or Tommy?
No, sir, sounds good.
Thank you.
Yeah, that makes sense. I mean, under the circumstances, for sure.
Okay. Then moving on to Article 5. D, 4, special rules of procedures. I. And this was an addition. In the event a quorum is not achieved for a regularly scheduled meeting, in application for final plat and any application for a final plat approval where preliminary plat approval has previously been granted by the board and no variances have been requested for the final plat application, the final plat, at the discretion of the planning director, may be executed by Pulaski County the next day after the missed regularly scheduled meeting. Staff will report any said plat executions to the board immediately by email, as well as in person at the next regularly scheduled meeting. So what this meant is we approve preliminary plats, and when we have done so, and then the party is ready for approval of their final plat, and there are no changes, and the board, at no fault of the petitioner, is unable to obtain a quorum, in those cases, when no additional variances or changes are being requested, then the final plat may be approved by the executive director, being Van, as long as he will notify the board of such action the next day. Any questions, Tommy or Patricia?
No, sir.
No, none from my
Down the
end.
line.
I mean, the only other thing I would ask about that is, so if there is some objection, then there is still a recourse. So if someone had an objection to that, they could appeal it, correct?
An objection? No. As far as appeal, I suppose you could to the quorum court, but I'm
So
going
so there is okay, so there is an avenue to, so if someone in the public had an issue with the decision, then it could be appealed to the quorum court.
No, it could not.
Oh, it could not. Okay.
It could be appealed to circuit court.
Oh, circuit court. Sorry, circuit court. Yes, yes, that's right. Sorry about that. Thank you.
All right.
Okay, and then on the Board of Zoning Adjustment bylaws, they are almost identical, except for the exclusion of that last addition, Tommy and Patricia, because this is the Board of Zoning Adjustment, not the Planning Commission. So the Board of Zoning Adjustment does not vote on or decide on matters having to do with development plats. So all the other changes are the same.
That is correct.
Agreed.
Okay, we are 3 minutes over, but I felt it was important and to go over this in the agenda meeting. So I will, at 3:03, I will call the regular meeting, October 26th of the Pulaski County Planning Board in order. First, I would like to officially welcome Patricia Blick and Tommy Majors as newly appointed commissioners to the board, and look forward to working with you guys. Next, I know we've already done the roll call Van. So also everybody should have a copy of the minutes from the September 21st meeting. Is there any changes or questions, concerns?
Mr. Chairman, I move to approve the minutes as presented.
Thank you, Mr. Wilson.
I have a
Okay,
second.
all right. Have a motion and a second. Any discussion?
Mr. Chairman, who made the second?
Tommy Majors. Which actually, we, Tommy, that I appreciate that, but we may need to get a different second because you weren't at that meeting.
Okay, I withdraw, sir.
That's kind of, you know, I don't mean to be sticky, but yeah, just in case there's any question.
No problem, sir.
Yeah.
No problem.
So I'll enter, we have a motion on the table to approve the minutes as written.
Second, this is Christie.
Thank you, Christy. Now any further discussion? All in favor, say aye.
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 Any opposed? Motion carries. Next, there is no old business, new business. Van, if you will proceed with the Shaheed family exclusion, please.
Yes, Mr. Chairman, this is a one lot family exclusion of roughly an acre in size on 145th Street. The applicant has provided the necessary information for the staff to recommend approval as filed, and that's what we do.
Okay. I'll entertain a motion on the Shaheed family exclusion.
Move to approve the motion, move to approve the Shaheed family exclusion as presented.
I'll second that. This is Dexter Dawn.
Hello, Dexter. Welcome. Thank you. All right. Any discussion? All in favor, say aye.
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 Any opposed? Motion carries. Stalcup Moorland Edition, Track 1R and Lot 1. Wait, Track 1R and Lot 1R, final plat.
Correct. That is mislabeled at the top. It is the Stalcup plat that we're looking at here, and you can see another picture of it here.
Very good.
And so it's a one lot, a two lot replat, and the only distinction is, or only difference between the original and this is a 30-foot addition from the west lot going to the east lot. And that's it. And the staff has received everything necessary to recommend approval as filed on the Stalcup plat.
Okay. I'll entertain a motion on the Stalcup Moreland Track 1R and Lot 1R final plat.
Cara
This is-
Connors, I will move to approve the plat as presented.
Thank you, Cara. Do I hear a second?
Second, Mark Wilson.
Thank you, Mr. Wilson. Any discussion? All in favor, say aye.
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 Any opposed? Motion carries. Next on the agenda is the PBGH Batesville Pike Lot 1 final plat.
Yes, this is a one lot plat, a replat of an existing platted lot for a location at the corner of Jacksonville Conway and Batesville Pike. And this is actually will be a Dollar General site. And the purpose of the plat is to provide dedication of the right of way on Jacksonville Conway and Batesville Pike to meet the master road plan requirements. The additional original staff comments that you see there have all been addressed, 7 through number 29 or 39, I'm sorry. The only thing necessary is for the applicant to provide a surveyor seal and signature on that, on the plat, and to note that they'll need to contact Tony Kelly and our in the Road and Bridge Department for inspections for those improvements they're about to make, and for them to obtain a driveway permit from Public Works for the driveway connection into the road, or roads, I should say. So the staff recommends approval as files, subject to what we just commented.
Okay, I'll entertain a motion on the PBGH Batesville Pike Lot 1 final plat.
I'll make
will.
a motion.
Okay,
Go ahead.
Mr. Majors, was that you?
Yes, sir. I'll make a motion. We accept it.
All right. Do I hear a second?
I'll second.
Okay. As,
Mr. Chairman,
yes,
is this where I would ask a question?
almost.
Okay. Well, I
Uh,
have a question about the
well,
before the vote.
okay, but yeah, so the reason why I said almost is because I was just about to say any discussion, but I was just, so we have a motion by Tommy Majors and a second by Patricia Blick. Now that we have a second, now I would say any discussion. So yes, Chrissy.
Okay. I was just wondering if staff could please advise the board on the effect this proposal might have on any adjacent property. I know that it has in the northeast corner, there's a residence, and I'm assuming that they received their certified mailing.
No, that what the requirement for a platted lot such as this, when it's adjacent to residential use, is a 40-foot setback. So they have to provide a 40-foot setback on the residential property to the, I guess it would be to the west there. And then they'll also have to provide 40-foot setback on Jacksonville Conway and Batesville Pike, in addition to the additional right of way they'll have to dedicate. And they'll also construct a widened shoulder to provide for pedestrian circulation routes on both streets.
Okay, so in these instances, their certified mailings are not required.
That is correct. There's no variances requested on this plat.
Okay, thank you so much.
You're welcome.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? Okay. I will Van, bear with me a second, because I think this, we have a lot of new attendees today and we have 2 new board members. This, I thought I would call out, Christie, I don't want to speak on your behalf here or put words in your mouth, but this is an example of a final, this was the, but we didn't approve this as a preliminary. I don't remember this.
That is correct.
So this is not an example of a preliminary.
No, it's a 1-lot final plat of a lot of record is what it amounts to.
Okay, all right. So actually, I'll just leave it at that. I don't want to confuse things.
Right.
But, yeah,
They're final platting the lot that they already bought that was in the configuration it is in order to dedicate the additional rights of way on Batesville Pike and Jacksonville Conway roads.
Right. So that's all that was required was the final plat.
Correct.
Thank you. I appreciate that clarification. Okay, motion carried. Next is the Waterview Estates Phase 3, Lot 44, and Phase 6, Lot 72 and 78, final plat.
Yeah, as you can see, these are 3 approved preliminary platted lots. The improvements are already in place. The applicant is simply trying to final plat these 3 lots for, I assume, for sale, more than likely. The staff comments that were on the write-ups when we originally sent them out have all been addressed. So there are no outstanding issues, and you can see the lots, the locations of them a little better, and the staff would recommend approval as filed for these 3 lots.
Okay. I'll entertain a motion on Waterview Estates Phase 3, Lot 44, and Phase 6, Lot 72 and 78, final plat as presented.
Mr. Chairman, I move to approve Waterview Estates Phase 3, Block 1, Lot 44, and Phase 6, Block 1, Lot 72 and 78, final plat.
Thank you, Mr. Wilson. Do I hear a second?
I'll second it.
Thank you, Mr. Majors.
Yes.
Now, any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Okay, on other business, we have we have, well, I've lost my bylaws. We have proposed changes to the planning board bylaws as well as the Board of Zoning Adjustment bylaws. As we discussed in the agenda meeting, these changes were discussed in a regular board meeting. Out of that came proposed changes that were, I believe, Mr. Hayes actually penned some of them, but staff did the rest. And so during that happened between the August and the September board meeting. And then at the September board meeting, these changes were read. Actually, the material changes were read. I did not read through all of the times where you guys took out a parentheses here and added a parentheses there. I did not do that. But all the material changes were read at our September meeting. As per the bylaws, it requires a reading of the changes to the bylaws at a meeting, and then the subsequent vote may be taken up in the next regularly scheduled meeting, which is where we are today. So Vanna, they're a little bit different, so I think we should take these up one at a time. The planning board bylaws, the material changes are there on the bottom left. Article 2, board members. Any member who is absent for 4 or more regular or special meetings during a calendar year, except in the case of illness or extraordinary circumstances, shall be considered to have tendered his/her resignation pending a vote of acceptance by the board. So we simply removed the verbiage, the word consecutive regular or special meetings, and stated that there was actually 4 consecutive meetings. It's 4 meetings in an entire calendar year. Any questions on that change? Okay, the next change is in Article 5, meetings, regular, Section A, regular meetings, 2A3, I should say. It was changed from, under no circumstances shall the number of board members attending the meeting by electronic means present, unless the Pulaski County judge issues an executive order canceling regularly scheduled public meetings due to public health concerns or for other unforeseen emergencies. It was changed from that to a minimum of 3 board members must be physically present at all board meetings unless the Pulaski County judge or the governor of Arkansas issues an executive order canceling regularly scheduled public meetings due to public health concerns or for other unforeseen emergencies. Any questions on this change? Okay, if not, then same article, section D, 4I, the following verbiage was added. In the event a quorum is not achieved for a regularly scheduled meeting, any application for final plat approval where preliminary plat approval has previously been granted by the board and no variances have been requested for the final plat application. The final plat, parentheses, at the discretion of the planning director, in parentheses, may be executed by Pulaski County the next day after the missed regularly scheduled meeting. Staff will report any said plat executions to the board immediately by email, as well as in person at the next regularly scheduled meeting. Any questions there? Okay, this is obviously, well, actually, unless anybody objects, I think what would be appropriate here would be, I'll entertain a motion regarding the planning board, the changes to the planning board bylaws.
Mr. Chairman, according to Robert's Rules of Order, I think we can have an informal discussion, can't we, before a motion is made?
In this case, I prefer to have discussions once we have a second, because if the order of business does not even obtain a second, then there is no purpose for the discussion.
Okay, I don't want to be contrary, but I would like that answered at some point. It is Robert's Rules of Order 4921, but I'm sorry, I do have a question, but I'll wait.
Okay, well, we can address that though. Unless told differently by the county attorney, I want to take chairman's privilege, or whatever you may call it, at my discretion. I feel like informal has its place at these board meetings for discussions, but the discussions on these particular items have already been had. Then we all agreed to the verbiage. And so I certainly will entertain discussion after a second. And I don't mean to be contrary either, but you know, I feel like an informal, when we're talking about the business of Pulaski County, I guess I want us all to be mindful of whether or how far to take our informal interpretation of Robert's rules. So absent, like I said, absent any instruction by the county attorney, otherwise, I would like to to go ahead and get a second, and then we can discuss this. We can have a period of discussion.
Mr. Chairman, I move to approve the planning board bylaws amendments as presented.
Thank you, Mr. Wilson. Do I have a second?
I'll second it.
Thank you, Mr. Majors. Any discussion?
Yes, Mr. Chairman, this is Christy.
Yes, ma'am.
My question is with the item DI that was added newly by staff. I just was wondering, to my recollection, it's only happened one time with a final plat, and that was when the developer Rick Ferguson was trying to present his final plat, and we couldn't make a quorum. I could be wrong, but I was wondering how many times has this happened, and if it doesn't happen that often, does it really warrant to change to our bylaws, especially since we're making our meetings more compulsory with our member meeting requirement and change in the bylaws, which I do support that. So I also wondered if we can change our bylaws to allow staff to approve a final plat and still be in compliance with state law as set forth in the Subdivision and Development Code. And that states it in section 1.4b. So these are my questions. I have a real concern for that. I would be fine to pass these bylaws, but I would like to strike that section out for more discussion. I would like to amend the motion to strike I. And so I move to amend the motion as presented to strike I, so we could have more of a discussion and make sure that I'm sorry.
Yeah, you cannot actually, we can, in the discussion, part of what can come out of the discussion is convincing Mr. Wilson and Mr. Majors to amend their motion and their second.
Okay.
But no, it just was not your motion to amend.
Okay.
I believe that you have voiced those concerns in the previous meeting, and it did still move forward. So is there any more discussion?
I guess I've tried to make my case. I'm just trying to abide by the code as I feel like it's written, and I feel that the board has a responsibility in the subdivision code. It's very clear on what responsibilities the board has, and that is to pass the plats, and what responsibility the staff has, and that is to assure that the documents are submitted properly. So they don't have that responsibility in the subdivision code. Everywhere in the code it says the board shall approve the plats. So that's just my, I'm not a lawyer. I know Adam is on this call, and I don't know if he would care to chime in, but I think I've said all I can. Thank you.
Mr. County Attorney, do you have any follow-up?
I'd have to read the code in the context of the circumstance in order to give any particular advice, but there are occasions where board action is not required when staff acknowledges that all of the requirements of the code have been met, and so it can be delegated by the board to the staff to provide for approval in circumstances, but I would suggest that those circumstances be very clear. That would be my recommendation.
And so, in your opinion, is this additional language, does it meet those criteria? I know that the reason why this came up, and I will address part of what you brought up in your discussion, Christy, Ms. Eames, this has only come up once since I've been on the board, which is probably, I guess, about 5 years, 4 or 5 years. And it's fortunate that it's only come up once, because we found ourselves with a petitioner being before us with a final plat to be approved. And there were the preliminary plat had been approved, and there were no changes or variances in the final plat that we did not already approve in the preliminary plat. Then comes the petitioner to the meeting, and we were unable to obtain a quorum. And it was unfortunate. And I know that some board members voiced their concern that potential impact to citizens and petitioners to the board be impacted by the inability of the board to obtain a quorum. So we felt like, I won't speak for the entire board, but I know in paraphrasing the discussion, the consensus was that having the 2 requirements in this section of this item I, where the preliminary plat approval has previously been granted by the board and no variances have been requested of the final plat application. So we would basically be approving the same article or petition that we have previously approved. So I know there was some discussion about, it seemed unfair that petitioners and citizens of Pulaski County be negatively impacted by the board's ability to obtain a quorum. So, Mr. Fogelman, you said, and maybe just to be clear, when you say we need to be, can you restate what you said?
Sure. So what I said was that the board may delegate tasks to staff. My recommendation is that when the board decides to delegate tasks such as approval of plats or acceptance of plats, that the instructions be very clear. And here, the preliminary plat would have already been approved by this body, and the final plat that follows it could only be approved and accepted by the planning director first on the exercise of the planning director's discretion, and in second, exercising that discretion only if a quorum could not be achieved at the previous meeting. And so that I think it's a reasonable thing that if the body itself, its members don't feel so compelled to show up for the meeting where the final plat is being considered at a regularly scheduled meeting, that it's reasonable to authorize that to go into effect, so long as what's being authorized is consistent with what was already approved, which is exactly what is provided for.
Thank you. So, and then to take it one step further, Mr. Fogelman, so assuming for a second that if this does pass, if anyone wanted to appeal this decision, they would go to the quorum court, or would it be the circuit court?
It would be circuit court. So appeals from the determinations of this body go to the circuit court. And I'll add, I would hope that this provision is never invoked.
Right. But
it's a safety valve.
Right. Agreed.
Mr. Chairman, may I ask one more question?
Sure.
If we can't obtain quorum, that means there's no meeting and the public is not able to come and speak. it's just another opportunity for them to speak at a meeting. So I'm just making note of that that is a negative. It's a sort of fallout, I think, from this action that the board is willing to take.
Duly noted. And if there is conversation that is passed because or missed because of this, I think that would be a potentially a prime reason why an appeal could be made to the circuit court.
Mr. Chairman, it's Joe White. Can I speak for just a minute?
Absolutely.
You know, I just representing developers. When we bring a preliminary plat to you and it's approved, and the developer builds the streets, utilities, infrastructure to develop the lots, it's hard to imagine that you would bring a final plat back and it would get turned down if you had done everything correctly according to the approved preliminary plat. And for that reason, the city of Little Rock and most other municipalities, we're not required to come back to the planning board or planning commission. We simply go to the staff. And if our construction has been approved and our plat meets all the requirements of the preliminary plat that was approved, it's approved at staff level. And so it's unusual that a developer would have to bring a final plat back in front of a planning board. And so I think this is logical that if in fact you couldn't get a quorum, that the staff could approve it. Thank you.
Thank you, Mr. White.
Mr. Chairman,
Yes.
Noelle Butsky. So to speak to Ms. Eanes' point on the importance of the community being able to have a voice, I think it is important that the needs of the community and its residents are always taken into consideration. And I think having multiple opportunities to do that, especially if they are unaware of what is going on until that final plat is brought to light, is important. And we should always have a final say on behalf of the residents of the community that this is being done in.
Would the community have the 30 days between the approval the first time and then the second meeting? Would they not have an opportunity to protest or put in their word?
That's a great question. And I would like to address that if I may.
Certainly.
I am a resident living on Roland Cutoff Road. And right now, Paradise Valley, the initial proposed plat, is actually going to put a waste treatment plant directly next door to my home, directly next door. And you provided preliminary approval for that. So thank you very much for doing that to my home. You're going to devalue my home and put a nuisance next door to me and did not take into consideration the residents who are going to be impacted by that. You provided preliminary approval. I'm probably going to be upside down in my mortgage and never able to sell my property. On top of that, we were never given notice from the builder, not anybody on the street, myself included. So notice was never provided to me. So I did not even know this was going to happen until the land was already starting to be cleared. So I would say notice is not adequate, because nobody on my street was notified. And I myself personally can tell you, I was never notified and did not even know anything was happening until August of 2021, that a waste treatment plant is my next door neighbor now. So I would like to know why the board thought it would make any sense to put a waste treatment plant in between two residential houses. Answer that question for me, please.
Ms. Butsky, I will do my best. We are charged with approving what comes before us in an unzoned area, which is the outskirts of the city of Little Rock in Plaque County, as you're well aware. Everything that was brought before us met the requirements that they had. So there has been subsequent conversations and possibly Some others here may be interested in that, of pursuing some actual changes, maybe a plan being implemented. But it is actually not in the jurisdiction of the planning board to take exception to developers who bring matters before us that have actually met all the qualifications. Now, you also mentioned about the notifications. That's another thing that could be, I'm a human, I hear you. I think that I and the other board members on the board are reasonable. And I don't think that there was ever any malicious intent. But I think that there are potential avenues that concern could be funneled through that may be more impactful, because we were presented with a proposal that met all of the existing requirements.
Mr. Chairman, may I address that, please?
Certainly.
My understanding is that the proposal that was given to you did not contain all of the necessary approvals, and yet you rubber stamped it, even though it was missing paperwork. That it did not have the approvals, especially from the fire departments, and I believe possibly the Board of Health. I talked to the ADEQ, and according to them, they were required to provide me notice because a wastewater treatment plant was going to be put next to my home. We were not given that required notice. So actually, he did not meet the bare minimum requirements as laid out in your own rules, and yet you overrode those rules and gave preliminary approval. So I would like to know why you were giving a builder preliminary approval when they did not meet the requirements as by your own rules.
It goes along with, thank you for the question. It goes along with precedents that we have set over a number of years. I know for as long as I've been on the board. When there are, staff is exceptional at bringing to us a summary or actually detail of all of the requirements that a developer that all the requirements that a developer has to check off. And in the case where there are items that are clearly articulated in the summary that's brought to us, then we have, I don't know how many years, but I can say at least 4 or 5 that I've been on the board. We have given staff, we have given approval for the preliminary plats subject to the staff under the executive director confirming that those additional requirements, be it paperwork or whatever, are obtained. Until and unless those additional stipulations are met, it is not approved.
Have those stipulations all been met as of today? And did you actually know what in fact you were approving? Because my understanding is there's some question about the waste management plans that were given to the Board of Health as opposed to the board, and that there was some question as exactly what was being presented. And I believe the ADEQ also opened up additional time for questions and commentary. So my question is, did everything actually get presented before the clearing started? Because the clearing is certainly well underway. And so if there is work that is being done for the preliminary, is that allowed? And is the precedence really a good idea? Because what you're saying is we really don't have to follow any of our own rules. We have these rules written down, but we're not going to protect the community. We're just going to let the builders do whatever. And then we'll just come on the backside and just fill it in later. And to me, that sounds like you're just going to rubber stamp whatever comes your way, and we'll just kind of fill in the details after the fact. And I don't think that's a really good way for a board to be running. If you have rules, shouldn't the rules be followed? And I guess I would ask the county attorney who's present, should we not follow the law, or should the law just be, hey, it's the Wild West out here, don't worry about the rules, we'll just take care of all of that after the fact?
So, Mrs. Butsky, I hear you and I understand your concerns. You started out with one question, but that's the only one I got. You asked, have they been met subsequently? And I can tell you that I do not know. And that does not concern me currently, because I know that the approval that we gave for the preliminary plat was subject to those additional requirements being met. And before they could come back for the final, that at that time, we would get an update on the status of all those, of the additional items.
Hey, Mr. Chairman, this is Mary Catherine Henderson. Can I speak for a second?
Yes, ma'am.
Hi, Noel. I live on the other side of the sewage facility. So my one question, if you guys are about to vote to not have to give final approval, but you've granted pre-approval here subject to, wouldn't that be like real bad for us if you're about to let the city just take that out of y'all's hands? If you're granting pre-approval before you have all of the boxes checked. Does that make my question make sense?
I think so, but I think it's important to note that whether it be a preliminary or a final, it's not actually approved until all of the requirements are met.
Okay.
That's staff's.
And you won't leave that up to the staff to do.
The
board will keep hold of that.
That is absolutely, in this case where we were unable to obtain a quorum, if there are no variances and the preliminary plat had been approved, then yes, they do have two things. They would have, staff would have the authority to approve the final plat, but if there were any remaining items left from the preliminary approval that were still not done, it is not approved. What we are giving them authority to do here is we are trusting them to make sure that everything is done in the end before it's all finally approved. And well, actually, to restate that more appropriately, it is not approved until everything until all the requirements are met.
Mr. Chairman, can I interject and ask a question of Van, of the staff? If there was if there's a change to, say, the structure of a treatment plant or that sort of thing that was not in line with the preliminary plat, that would necessitate, even under these new rules, that would necessitate it coming back to the board for approval. Is that correct?
If the septic system is approved by ADEQ and the health department, that is our requirement.
Okay.
If the sewer treatment facility, wherever it is and however it may work, if it meets health department standards and is acceptable, that means our subdivision has approved sewer along with water and whatever else there might be. So it would be approved as far as we were concerned.
So in this case, if ADEQ does not approve, then that would need to come back. I mean, we wouldn't approve it.
That's correct. If they cannot prove to the staff that, if the developer cannot prove to the staff that they have approved health department septic, then we can't approve the preliminary plat. We cannot give approval to the preliminary plat as provided by the planning board. And even so, when this subdivision comes back and the final plat proposal, all of that will be on the board's table at that time. I mean, whatever variety or way that the septic's been approved or not approved, that would all be on the table for the board to discuss and investigate.
Okay, because even with the new language, as long as we have a quorum at each meeting, then the staff is not approving anything without our say. And
correct.
And where we didn't have a quorum, we would still have members, present, and we would have to have at least one or two members to even meet. And so we would be aware of the situation and able to advise the staff before approval of a final plat.
Right. I mean, in this particular instance, the last instance that we were talking about in terms of the lack of quorum, the board and the public were given notice of that public meeting. We held a public meeting. We just could not achieve a quorum. And yes, the answer to the question is we've had multiple times we have not had a quorum. It's not been recently, but when we are down a position or two, when it has not been filled, then we run a risk of not having a quorum all the time. And this summer, we had to battle almost it seemed like almost every week. Every month when I was texting people, as we were trying to achieve a quorum on the day of the meeting. So we don't want to have that. And if we were to have that situation, and if there was a approved preliminary plat that had no variances, as the county attorney discussed, then there's no reason for us not to approve the final plat, because basically Supreme Court law has already dictated that if a plat meets the ordinance requirements, it must be approved. It's not like a zoning or conditional use permit or something where there's more discretion. There's not much discretion here if everything has been met and approved.
Thank you. And if Mr. Chairman, if you might indulge me for another question of the staff regarding notice, the current county ordinances only require notice to adjoining property owners. Is that correct?
No, it requires, if there's a variance request, it requires notice for all adjacent property owners, including property owners across a public road from it.
Correct.
For example, the city of Little Rock, on subdivisions, they do require notice. They don't post anything on the property, but they require notice of adjacent property owners, not our. So when we don't require notice as a general rule, but if there are any variances to the subdivision ordinance proposed on the subdivision, then we do require notice, and that includes all adjacent property owners and the property owners across the road from the site as well.
Okay, so just to clarify your answer, there's no notice required if there are no variances to county ordinances.
For a subdivision, that's correct.
Okay, thank you.
And no notice for wastewater treatment, correct?
There is some sort of notice that the health department and ADQ goes through, but I'm not privy to what all that is. They do require, if I recall, based on my conversations with them, they require a notice in the paper of general circulation. There's some sort of a notice in the newspaper when they have a proposed plan.
So Mark, I didn't get any notice.
I did not get any notice either. They did not provide any notice to the people affected by the water treatment plant as required.
Yeah, I understand y'all's concerns here.
Mr. Chairman, I have two more questions if you don't mind.
Certainly.
And Mr. Fogelman, maybe you can answer as well if this is actually something more up your alley. But my question is, in the term of notice, if inadequate notice was given, but you've already given preliminary approval, is that something that would require the preliminary approval to be rescinded because it's impossible to have given approval at that point? And then my other question would be, if the conditions are not met, but the builder has already done all of the clearing and the roads and everything else, what do you do in that case?
Those may actually be staff questions. So first, I don't know that the county's ordinances regulate. In fact, I know they don't regulate the use of land in the unincorporated areas. So if somebody wants to clear cut their properties and regrade, there may be other legal issues that accompany some of those actions, but it's not something that's regulated necessarily by the county. And I always have to say with an asterisk, because it always depends on the location and the circumstances surrounding any individual property. I don't particularly like to dwell in hypotheticals because there's always an exception to the rule, and there are always other rules that may be invoked. With respect to your question on notice, I believe what Mr. McClendon indicated was that if variances are not requested, then notice is not required. You mentioned notice with respect to the sewer treatment facilities, but that's an aspect of a development that is outside the jurisdiction of the Planning Commission.
Okay.
And so that is an aspect that you would need to address with that governing body, which is ADEQ and the Health Department.
And is the practice of the Planning Commission to ignore its own rules something that is acceptable?
I can't.
Was that directed the county attorney or?
Yes.
Statement?
The
Okay.
fact that they decide that here are rules of what's required to get a preliminary approval and then just ignore it and give it to them approval anyway.
I
Is
can't
that
acknowledge.
something that is acceptable from a legal standpoint?
I think I would reject your premise that acceptance and approval of preliminary plats is occurring without meeting the conditions of the ordinance.
Okay, so if someone were to show up with all, in this case, they did not have all of the required paperwork, but were granted preliminary approval anyway. Without all the requirements.
I'm sorry, Ms. Pesky, because you've said that a few times.
Yes.
It's important to note that even though this has happened a number of times, as I've mentioned over the last several years, it has never occurred where it was blanket approval. That's not an accurate statement. What it has done is conditional approval upon staff making certain that all of the requirements are met, and it is not approved until those conditions have been satisfied. Does that?
Chairman.
Mr. Chairman, my
Yes.
name is Dan Hedges. Can I make a statement about this?
Certainly.
Yeah, thank you for letting me speak on this. I'm Dan Hedges. I'm an officer for the Nowlin Creek Neighborhood Association. Several years ago, developers were attempting to develop high-density housing with the extraterritorial jurisdiction of Little Rock. And the Nowlin Creek Neighborhood Association, excuse me, and the citizens of West Pulaski County launched a petition to halt this type of land use. And during the hearings with the Little Rock Planning Commission and the Board of Directors, our group presented the evidence supporting our claims against the urban sprawl, that's what this is. This is just urban sprawl. Both the Planning Commission of Little Rock and the Board of Directors sided with our argument and rejected the permit request that would have allowed this leapfrog development to occur. And all of this evidence and testimony is a matter of public record and can be accessed at the Little Rock City Hall records. So you can also Google it. It's out there on Google as well. And I have a big concern about the lack of land use planning in Pulaski County. It will be detrimental to not consider the needs of fire protection, police protection, traffic control, water usage and supply for this development, and also wastewater management prior to approval of any of these plats. I'm not so sure that there's enough water in these areas to supply to put out a fire in these high density developments. I have been told by the chief of the fire department at a Little Italy meeting that he was also expressing some concerns about the ability to put out a fire if there was going to even be enough water. That's the comment I wanted to make about this. And so I just wanted you to know that I, as a citizen of West Pulaski County and Nowlin Creek, have a big concern about this.
Understood. Unless the county attorney has anything else, I believe that the remedy that you guys may seek, Mr. Hedges, would be outside of the planning commission. I hear your comments and I understand them.
Well,
As Mr. Clendon
we
said
have received a
earlier,
remedy because the Planning Commission of Little Rock, which controls the extraterritorial jurisdiction,
right.
sided with us and rejected the permits required.
I understand, but we're outside by definition.
Yeah.
We're in the county outside that. So I was just, if you'll let me finish my statement.
Yeah.
I think that the remedy there would be outside of the Pulaski County Planning Commission, and with any agency that may be able to pursue a land use plan. As of right now, as Mr. McClendon has said earlier, it's been challenged, and the Supreme Court of Arkansas has upheld the fact that if a developer has met all the requirements, it is our responsibility to approve it. So absent any use plan that comes beyond this date, we're acting as unless, am I saying anything wrong, Mr. Fogelman?
No, and I want to be clear that the cities have zoning authority not only within their incorporated boundaries, but in the extraterritorial zoning jurisdiction, the ring around the city. Beyond that ring, the county quorum court has zoning authority. But that's a policy question that would have to be posed to the quorum court on whether and to what extent and how zoning should be implemented, of course, with the input of this body. So you're asking, it's a policy question that would have to be addressed by the quorum court. Like I said, this body can weigh in, can present its plan, its recommendations, but this body doesn't have any authority on its own accord to actually implement zoning unless it's given that authority from the quorum court.
Mr. Chairman, I'd like to make two comments, if I might, on that example that was used on the Nolan Creek. First, the volunteer fire chief has the ability to comment any way he or she chooses to do so on this subdivision that we're talking about here on Roland Heights. So the volunteer fire department has every right to say whatever it is if they don't think there's adequate fire protection, it's an issue. So they have an opportunity to say whatever they need to say. Secondly, the primary difference, as Adam alluded to, in terms of the two situations that we're talking about here, one is the most important is that the Nolan Creek in the city's extraterritorial planning jurisdiction had zoning, and the city of Little Rock adopted a zoning amendment to change their zoning law to allow or require a conditional use permit for package plants in their zoning area, which included the extraterritorial area. So the conditional use permit was applied for, and I think ultimately denied by the city of Little Rock Planning Commission and maybe upheld by the board of directors. So that's the primary difference in this situation we're talking about.
Mr. Chairman, I'd like to make a comment, if allowed to. My name is Christina Santafonte, and I live right next door to this new development. And I have two things I wanted to mention. The preliminary plat actually had two variances associated with it, if I recall correctly. So there were actually two variances associated. So I assume that means the people across the street should have been notified. And number two, when we went to our first meeting, October 16th, the fire chief had not even been notified. So there is no approval on that yet. I don't know if they've even contacted him. So I just wanted to put that in the record. Thank you.
Thank you.
Chairman, Daniel, this is Commissioner Connors. I just wanted to inquire on, in kind of a point of order on the basis of the motion, is to include a caveat whenever there is no quorum. How is there a way to balance both competing interests? I mean, obviously, the public has an interest for the board to do board duties, but also we have concerns of the balancing of power between the staff and the appointed board and the purpose of the board. Is there a way to notify the public or members of the board and members of the board when the decision is going to be held for the executive director to approve a final plat? Is there a way for to avoid the cost of litigation? Because basically what we're saying to members of the public are, if you miss out on the meeting or if there's no quorum, kind of like, too bad, too sad, go file a lawsuit is essentially what we're telling members of the public. And I, as a litigator, I'm sure Mr. Fogelman, as a litigator, you understand the costs that go into that. It's not cheap. It's not easy. By the time you file an injunction or whatever cause of action you may have, construction may have started. I mean, the damages could be great to a landowner or a homeowner that is adjacent to whatever the concerns are. And so I'm trying to put myself in the shoes of someone like the public that has come before us, and what can we do to safeguard both the process, the procedure, as well as balance that with the concerns of the constituents, because we are appointed members of the public. Our job is to represent these homeowners, these property owners, and balance the interest of the builders and balance the interest of landowners. And so is there not a safeguard or a procedure, maybe a 5-day window within the bylaws to allow for some type of remedy? Is that something that can be considered or contemplated?
Currently, thank you, Cara. Currently, we state in the proposed change, if the preliminary plat approval has previously been granted by the board and no variances have been requested for the final plat application, the final plat, at the discretion of planning director, may be executed by Pulaski County the next day after the missed regularly scheduled meeting. So are you stating, maybe requesting that we consider a change to the time between the missed meeting and the time where Pulaski County, at the discretion of the planning director, may actually execute the approval?
Yes, because obviously we want to be, expeditious in how we get these plats approved, but, we want to ensure that if there's no public meeting held, that there might, if there were, members of the public that were in attendance that could have brought things to the board members' attention that might change the approval of that final plat. Even if it met preliminary approval, there are things that may come up that might put a pin in it or maybe cause board members to vote against it. I don't know. The scenarios are, ever changing, and we don't know what every plat will bring forth, what concerns those plats might bring forth. So, we know Van and his staff do an amazing job of bringing things to our attention, and highlighting those plats that need to be held off or not voted on, or things that have not been properly administered. But as the members of the public have brought to our attention today, there might be concerns with some of those plats that maybe the staff didn't recognize, or maybe that could be challenged later on. And that's why these are public hearings, for people to come from a different perspective and bring information. And so we don't want to eliminate that balance from the process, because it's a process for a reason. And we understand, we don't have a quorum, and business needs to be conducted. That's very important as well. But, there is a process for a reason. And it's to ensure that all voices have an opportunity to be heard. And so if we're not going to have a public meeting and there's going to be essentially an executive order entered or an executive decision made, then I think that there should be some type of available remedy outside of litigation for members of the public, whether it be extending it for 5 days after the public meeting were to be held. I think that we deserve to give the public some kind of opportunity that would protect both interests here. That's just my 2 cents. I didn't attend the first meeting that approved the amendment, the proposed amendment, or discussed it, or I didn't review it prior to today. So I wasn't there and I wasn't privy to the conversations, but just from my legal training, you want to always give due process. You always want to give people an opportunity to be heard, and you want to exhaust those administrative remedies before you have to go to a court of law. And so that would just be my own.
Mr. Chairman, if I may, I don't think the concern here is really, I don't think the big problem is whether we let the staff carry out the final plat as long as there are no changes. I think the big concern of everybody who's spoken today is proper notice, and that adjacent property owners and adjacent property owners are given effective notice. I'm sorry, was there a comment? Oh. That people are given proper notice in order to hear what's going on in their area. And so that unfortunately is outside of our area of that we have jurisdiction. Well, it's out of the scope of what we do as a planning board. All we do as the planning board is say, is this plat, this plan meeting the county ordinances? And that's exactly what we did. And so we have not seen the final plat, and we have not seen if there's approval by the Arkansas Department of Health and Central Arkansas Water and the other entities involved. So I'm completely sympathetic to the members of the public who are making comments here that you feel you didn't get proper notice, and whether you got notice that is fair and whether you got notice that meets county ordinances, those are two separate things. And I'm very supportive of further, expanding notice on items like this, but I don't know how that is accomplished. And the other comment is, if we get past that, if we get to where people feel there is proper notice, then I think everybody feels heard and we don't have this issue. But I think we can approve these amendments and address, and citizens can address getting proper, effective, fair notice after that.
Thank you, Mr. Wilson. Patricia, Ms. Blick.
That's okay. Thank you very much. Mr. Chairman, I was wondering if maybe what we could do, and I don't really know, Van, you'll have to educate me about this. Do we have a timeline by which we have to approve an application? Say, for example, that if an application is received and it's complete, we have to respond within 90 days. Then that would also trigger basically that approval if we can't make quorum by then. Because my thought is maybe, because it is, as you said, hard to validate, we're going to have a quorum all the time. Maybe we should say it not approved immediately after that initial meeting where we didn't have a quorum, but give it a second round or something along those lines. So there's a little bit more time, but it's also not too lengthy that it would impose a hardship on the developer as well.
So I know that may require a response from Mr. McClendon, but we do have two conversations going over here, and I don't want to squelch either of them because I think it's all very healthy. And obviously, with the number of people here today, I think these conversations need to occur. And I'm in previous boards, including this one, I always want to facilitate communication.
Mr. Chairman?
That said, just a moment, Mrs. Zines. That said, I would ask Mr. McClendon and Mr. Fogelman if there's a historical or a legal reason why the notification requirements of matters that come before the board are not governed by this board. Is there a reason why our bylaws or our scope of authority does not include the notifications? Do either of you know that, Adam?
Mr. Chairman, the notice requirements are outlined in our ordinance, and the planning board has the authority to, or the duty really to propose an amendment to our ordinance following or with regard to notice requirements if it deems it's important or necessary. And if that's the case and an amendment is proposed and the planning board approves it, it goes to the quorum court and they think it's satisfactory to require whatever notice that might be, then you'll have an ordinance amendment and you'll have a say over what the requirements are.
Okay, thank you for that. And just so everybody understands, there for a moment, I was just thinking about our bylaws and forgot about the ordinance.
Right.
So the ordinance that created this body, we can make those adjustments. And I think that we've heard enough today, and board members have actually chimed in as well, that there is a concern from citizens and the board that notices the requirements for notifications should and should be revisited. Okay, so before I move on, is there anything new to comment in regards to the notifications? I want to do my best at. Okay,
Mr.
Siri
Chairman.
apparently had an objection.
Mr. Chairman,
Mr. Chairman, this is
Christy. Yes.
Mr. Chairman, this is Christy.
Uh-huh.
As you know, we discussed prior to this meeting that I had wanted 3 agenda items added to this meeting, and one of them is changes to the notification process. So staff and the county attorney are aware that I'm going to discuss that today. And I'm also planning to discuss a land use plan, which has also been touched upon today. And I would also like to discuss the subdivision code as it applies to preliminary plat filings and certifications. So I just want the board members to know this, that I was planning to discuss some of this today. Thank you.
Thank you.
I'm sorry, that you're planning to go to the quorum court, is that what you said?
Oh, no,
Oh,
Commissioner Wilson, I was just going to introduce some changes that I propose, some changes to the subdivision ordinance as it applies to notifications from what I've heard from the community.
okay.
And I wanted to discuss that with the board today. And as I'm aware, as I was told, I can't make a motion today, that I need to have it in writing. So I want to get input from the public and from the board. And I'm supposed to put it in writing and email the board. And then if you all approve it, then it will go to the quorum court.
Thank you.
Good.
Thank you.
So then back to me attempting to be methodical about how we move forward. Are there any other questions about the notification process or requirements? Okay, then let's move back. We have a motion and a second on the floor. This is the Board of Zoning Adjustment. It would be, yeah, the next one, just so there's no confusion. In regards to the amendments to the Planning Commission, is there any further discussion? There's been plenty, but we do have a motion and a second on the floor that needs to be addressed.
Okay, Mr. Chairman, my motion was on are we going to vote on both of these at the same time, or do we need to vote on them? Okay, so my motion is on the planning board bylaws amendment.
That's correct. And Mr. Majors seconded, I believe.
Yeah, and I just want to add to address Ms. Boyd Connor's comments, kind of going back to the statement I made a little while ago about notice. I don't think another 5 days is gonna change the way this process works. If somebody wasn't, effectively noticed in the, preliminary plat, they won't be effectively noticed, 5 days after there's not a quorum to approve the final plat. So I think these are two different issues, and I would like for the board to move forward with approving these bylaws, and then I fully support, efforts to improve proper notice to all citizens in surrounding areas.
Mr. Chairman, I do have one more mention, if I may.
Okay.
Our new board member, she had asked about, extra time. We actually have had special meetings called whenever we have missed a meeting. And so why don't we still do that? Why do we need an amendment into the bylaws? We have already done this. When there's not a quorum, we've called a special meeting. So why is that not acceptable anymore?
Well, it's not that it's not acceptable anymore. It was different in that case because there was actually a variance.
Okay.
There was a variance. If you're referring to the one maybe 4 months ago, Mr. White and Mr. Ferguson, there was actually a variance, and they had to have a final. They would not have met these requirements.
Why can't we do that with this too? I mean, what's to stop us from having a special meeting?
Because it's the planning commission, it's the board's responsibility, not staff, to make approval if a variance is requested. And the let me finish, please.
Of course, yes.
There was a variance requested in that case that needed to be addressed. And in this case, that's particularly why I believe in this bylaw change, it says preliminary plat approval has previously been granted by the board and no variance have been requested. In that case, there was a variance requested. So even under these adjusted bylaws, that particular case would not have been acceptable. We would have had to either wait or call a special meeting. We did call a special meeting of the board that time because we did have the option of waiting, but it was the consensus that, or I will say it was certainly my intent, not to cause anybody that comes before this board to be negatively impacted by the simple fact that we could not obtain a quorum. So that's the reason why I was very not only apologetic to the petitioners, but sympathetic to their request to go ahead and move forward. We met 1 week later as opposed to 4 weeks later or 5, whatever, in that case, and time is money. So that's, did that answer your question?
Sure. Well, it just seems like it's mainly an inconvenience move, in my opinion, that it's just an inconvenience, maybe to staff.
On the party, inconvenience to whom?
To staff, to have to, wrangle us together to get us to have a special meeting. So we've lost I've lost Mr. McClendon's video, by the way. So I just wanted to state that we have done that before, and it doesn't matter for what reason, but we apparently we can write whatever we want. And so I don't see why we can't continue on with those specially called meetings rather than doing kind of a big, I feel like it's a major thing to modify our bylaws. I don't think we should modify our bylaws just for any small thing. I don't want to belittle this or anything, but it seems like a special circumstance. And I don't think bylaws are designed to account for such a special circumstance that we can address another way.
Duly noted. Any other discussion? Okay, all in favor, say aye.
Oh, I'm sorry, Eric.
Yes.
I would just recommend in regards to the and back to Article 2 in regards to the extraordinary circumstances. I think Commissioner Bleak brought that out, that the extraordinary is not defined. And I think you probably should, considering that we're making these adjustments for lack of quorum. And we don't necessarily know why board members are unable to attend. And so there might be some extraordinary circumstance. So I would just recommend that that there's be some later amendment or going forward definition of extraordinary circumstances, so that all understand that why, if their absence is not, the purpose of their absence. But that's the last comment I had.
Thank you for that. I actually had that same thought previously, and so let me reread this. Any member who is absent for 4, this is the new language if approved. Any member who is absent for 4 or more regular or special meetings during a calendar year, except in case of illness or extraordinary circumstances, shall be considered to have tendered his or her resignation. And this is what got me and made it okay, in my opinion, was pending a vote of acceptance by the board. So in other words, if I have had extraordinary circumstances and I haven't wanted to share those extraordinary circumstances or haven't for whatever reason, and my resignation has been considered to be tendered, my resignation still has to be accepted by a vote of the board. So that is the point to where I know I would never take on a vote without a discussion. And that's where that board member would have the opportunity to explain the extraordinary circumstances. I don't want to put words in your mouth, but I felt like that would number one, cover us, and number two, if the majority of the board agrees, would allow us to avoid a particular definition of extraordinary circumstances that may box us in the future and to the detriment of that board member, potentially.
I agree, Mr. Chairman. Thank you.
Any other discussion? Okay, all in favor say aye.
Aye.
I'm sorry, with this much discussion, let me rephrase that. All in favor of approving the bylaw changes to the planning board as presented, say aye.
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 Any opposed?
No.
Nay.
Nay.
Okay, so there's 6 here. So Patricia,
Yes, I was a nay.
okay.
And I know I'm new to this discussion, so I appreciate the opportunity to hear all of the discussion.
Absolutely, absolutely. I'm sorry, you guys. Christine,
No.
Mark Wilson,
Yes, aye.
Cara Boyd Connors,
Nay.
Tommy Majors.
Yes. Aye.
Okay, and I am an aye, so we have a tie. Oh wait, no, Dexter's here.
Actually-
I'm sorry. I'm sorry, Dexter, are you still here?
Yes, I'm still here.
Are
And mine is yes.
And what was your vote?
A yes.
Okay. Sam Kaufman, Pat Hayes. Okay, then the motion carries. Changes to the bylaws to the Planning Commission have been approved. Next order of business is the bylaw changes to the Board of Zoning Adjustment, which, as we noted earlier, are the same changes with the exception of the exclusion of the last item about the quorum not being present or being able to be obtained, giving staff authorization to approve final plats. But let's do our due diligence. The first proposed change to the Board of Zoning Adjustment bylaws is in Article 2, Section A, under members. Any member who is absent for 4 or more, the old word verbiage is, any member who is absent for 4 or more consecutive regular or special meetings, except in case of illness or extraordinary circumstances, shall be considered to have tendered his/her resignation pending a vote of acceptance by the board. The new proposed language is, any member who is absent for 4 or more regular special meetings during a calendar year, except in case of illness or extraordinary circumstances, shall be considered to have tendered his/her resignation pending a vote of acceptance by the board. The next material change is to Article 5, Section 2A3. The existing language, I should say, states, under no circumstance shall the number of board members attending the meeting by electronic means exceed the number of board members physically present unless the Pulaski County Judge or the Governor of Arkansas has issued an executive order canceling regularly scheduled public meetings due to public health concerns or for other unforeseen emergencies. The new language, proposed language, would be, a minimum of 3 board members must be physically present at all board meetings unless the Pulaski County Judge or the Governor of Arkansas has issued an executive order canceling regularly scheduled public meetings due to public health concerns or for other unforeseen emergencies. Excuse me, those are the 2 material changes being proposed to the bylaws of the Board of Zoning Adjustment. I'll entertain a motion on these changes.
Mr. Chairman, I move to approve the Board of Zoning Adjustment bylaws amendments.
Thank you, Mr. Wilson. Do I hear a second?
I'll second it.
And that was Mr. Doing?
Majors.
Majors, okay.
Mr. Chairman, for a point of, Mr. Hayes has been admitted to the meeting too.
Okay, all right. Mr. Hayes?
Don't tell me how late I am. I got on a conference call with a judge and another lawyer, and you know, I told them, I said, I got more important things to do, and they didn't like that. So anyway, they finally let me go. Sorry.
Okay, well, you are familiar, Mr. Hayes, with these. I believe you helped pin these changes. We are now voting on the proposed amendments, to the bylaws of the Board of Zoning Adjustment. And we just read through the two material changes, Mr. Hayes, the first being in Article 2, Section A, members, where we changed it from 4 consecutive regular special meetings to 4 meeting special or regular meetings in a calendar year. And the second being in Article 5, Section
In a board meeting.
A2A3, where we change the verbiage from under no circumstances shall the number of board members attending a meeting by electronic means exceed the number of board members physically present, to state that a minimum of 3 board members must be physically present at all board meetings. Mr. Hayes, are you familiar with these changes?
I am.
And you're okay with us proceeding with the vote?
I was ready to vote.
Okay, all right. Any further discussion? We have a motion and a second on the floor. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Okay, next item on the agenda is chairman communication. I'll just say that I appreciate all the communication today. I have been on boards with neighborhoods and so forth before, and I think it is, as others have already stated, it's critical that that those appointed to represent citizens, be it developers or residents, hear those that come before them. So I appreciate everybody's attendance and the homework that's gone into today's meeting.
Mr. Chairman, I'm Kathy Wells. May I make a point of information?
You may certainly do so, Ms. Wells. It's good to see you.
Good to see you all having good grassroots democracy. I have also been very invigorated at the back and forth today. And I wanted to check about whether this recording will be posted online and will be made available on a YouTube channel so that absent friends might be enabled to take advantage of it and learn from it.
I believe so. I'll leave that to staff. Van, remind us what the availability of the recording is.
Yeah, we do have the audio recording of the meeting, but it will only be available on request. We don't have it posted anywhere. We just have it for the record. We have it for record purposes.
Could you start the process of putting up the YouTube or the recording somewhere on the city government website and your own page and stuff? I'm more familiar with how they do it in the city of Little Rock, of course, and there you can look live on their Facebook page at their major meetings. Plus, the recording is then posted on their YouTube channel. And
yes, I think we might be able to.
Good democracy.
I think we will investigate with the public relations department about posting the audio on the YouTube channel of the county.
Thank you so much.
Thank you, Ms. Wells. And Van, if you will please take an agenda item to report back to us at the next meeting, what progress there is to report.
Will do.
Thank you, sir.
You're here.
Now on, next item is staff communication, discussion of methods for proposing changes and amendments to county ordinances. Van, this, was this, where are we going with this one? Was this here for the 3 items that Mrs. Eanes planned to bring?
Van, you're on mute.
Van, are you speaking on mute? Yeah, you're on mute.
Now I'm not on mute. I got it. Yeah, we knew that there was like, well, we knew after having discussions last time and prior to this meeting that there's going to be some conversation about, at least about the idea of it, if not the specifics of it. And so we used that as a staff communication item. And I know that there is a board member that wants to discuss 3 different items. And if the chairman would indulge, I think I might give you an idea of how we think it might work, or unless you just want to explain how you think it works.
I will, Mrs. Eames, are you okay with Mr. McClendon sharing some initial thoughts before you bring your 3 items before us?
Absolutely. Or if you'd rather me say mine first and then you tell us how it can be done. I have some specific changes that the community has asked me to present.
I understand, Mr. Chairman. So however you want to proceed with it's fine with me.
Well, Mrs. Eames initiated this conversation, so please proceed, Mrs. Eames.
All right, well, thank you. I'll be brief, everyone. I know it's a long meeting. I have 3 minutes, so on each item. I live in the unincorporated area of Northwest Pulaski County in Little Italy, a historic community, and it's between Y and Roland. And it's come to my attention after attending several full house community meetings in the area that the current subdivision code's notification process is ineffective at doing what it is supposed to do, notify. For example, there was a preliminary plat presented in February this year, attended only by 2 residents opposing it. Suspecting this, I went door to door to do my own research. Most of the people did not know about the development. So I did speak with Adam Fogelman, our county attorney, who is here today, to get guidance a month or so ago in regards to notification changes to the code. And the county subdivision development code is the law that applicants follow in making notifications in the unincorporated areas of the county that are not governed by the Lake Maumelle watershed zoning ordinance. So the suggested changes suggested by the stakeholders I spoke with are, they would like a 30-day notice versus the current 6. 6 includes the day of the meeting, and it is also really 5.5 days. It's not even a week. The second change is to notify residents within a ½ mile of the boundary of the property versus those abutting or across alleys and streets. This is inadequate in a rural area where people live acres apart from each other. For example, in the Paradise Valley notification process, 6 were alerted, including the developer's own address. So that was really 5. There are hundreds of people living in the immediate vicinity of the development who didn't know and had no opportunity to voice their concern. The other change is to ensure notifications for any non-contiguous land, which is still part of the subdivision. For example, property owners next to Paradise Valley's wastewater treatment plant site, which is across the street from the development. It's not within the development, it's across the street. We're not notified. To change an accurate source for addresses instead of using an apparent inaccurate source from an abstract firm showing the property owners taken from tax records. The community has reported to me that the addresses were out of date in regards to Paradise Valley. Pages is a Pulaski Area Geographic Information System. it uses a combination of CAW customer addresses and the county assessor's computer assisted mass appraisal database, or CAMA. And they have a 95% plus match rate. I would like to add to provide notice of the developments on the Pulaski County website. I would like to add to provide physical signage on the sites. So those are the proposed changes, and I would like to open it for Q&A. I think that's what the chairman recommended we could do. I'd like to get input from the board members and from the public on these suggested changes. And I know many of them have already spoken. So they may not want to speak again on the topic, but I would like to get your input. Thank you.
So just real quick, Mrs. Eames, two things. One, I've got the 30 versus 6. I've got days, and I've got number 2, the half mile versus adjacent. Somehow I think there was a third, but I didn't. I think there's 5.
I think there's something amiss in the code where if there's non-contiguous land, if there's a wastewater treatment plant, for example, in Paradise Valley's situation, it was not within the development. It actually was across the street. And the people that live right next to that treatment plant and that proposed site were not alerted. So if that's something that we could add, that if there's any non-contiguous land associated with a development, that needs to be included, and those property owners need to be included in the notification. I hope that's clear.
So is it the non-contiguous land or the fact that it was a treatment plant?
Non-contiguous.
Okay, so then are you stating that any non-contiguous land would also need to meet these other requirements?
Well, I think they should. I'm proposing this. I feel like if there's a site and it's got another piece of it somewhere else, wherever that other piece is, the people next to it need to be notified.
Within 30 days, not 6, and a half a mile of it, not
yes,
adjacent.
Yes, exactly.
Okay. And then the fourth, I believe, was that the notification gets the names and addresses from Pages as opposed to an abstract company.
Yeah, Pages, they use Pages and a combo of a CAW customer addresses, which I understand that CAW Pages is now under CAW jurisdiction.
Central Arkansas.
And yeah, I think so. And the county assessor's CAMA database, okay, because they have a 95+% accuracy. So there are some people that I've heard from that said that the addresses that were sent out for Paradise Valley, some of them were inaccurate.
Okay, and then the 5th was physical signage. Is that correct?
Yes, physical and on the website. And so there are 2 there, yes.
Do you intend on making those together? Well, it's okay, finished.
I guess they'd be 2 separate.
Okay, and then 6 would be web notice. Okay. And then the second thing I had is I know I agree with you that we've already had a lot of this discussion, but I don't want anybody to feel that that their voice is not being heard adequately because we're having a second conversation. That said, I just ask that everybody just, if you want to comment, that's wonderful, and I welcome that. Let's just keep it. You're welcome to comment. Let me just leave it at that.
And Mr. Chairman, all of our contact information is publicly available on the county's website. if folks want to contact us outside of this meeting,
That's
and
a
let me
very
get
good
on to
point.
dinner with my family.
Yes, that's a very good point. Okay.
And just one comment that I would like to add to this.
Mhm.
I would like to thank Mrs. Eames for bringing the voice of the community to this, and looking out for the community by bringing this to the board, because that is something that we definitely need. So thank you for being the voice of the community here.
Thank you, Noel.
Really noted. Okay, if there are those that would like to speak, like I said, I do just ask that we be brief and concise. But if you would like to speak, let me back up a second. As Ms. Eaton said, the expectations I set on this with her previously was that for each of these three items, she was welcome to speak for 3 minutes to introduce the topic. And now there's followed by a Q&A from both, as she said, the board or attendees. So just to remind everybody, the purpose of this discussion is for Mrs. Eames as well as other board members to develop a broader understanding of the matters that Mrs. Eames is bringing before us today as a result of hearing perspectives from other individuals. So as a result of this introduction that she's just given and this discussion, that's the reason why I asked her to hold off on the motion until subsequent to this conversation, so that then she could consider these other perspectives that may or may not be gained from today's conversation and incorporate them into her motion that she is more than welcome to make at the next meeting. I'm sorry, to bring the written version of that to the next meeting. And she's more than welcome to make that, to share those written comments to the board prior to that meeting. Then at that meeting, we will have another conversation we will read the specific language that she proposes, and then any further discussion at that time, and then a follow-up, the subsequent board meeting. Following that, there will be a vote on anything that survives after that, after the November meeting. Any questions on that? Okay, would there like to be anybody would like to speak on the board or attendee?
Mr. Chairman?
Yes.
My name is Nicholas Valdez. I own property that abuts Paradise Valley. And I would just, I'd like to confirm Ms. Eanes' statement that notice was inaccurate and inadequate. My wife and I purchased the property 2 calendar years and had lived on their property for 2 calendar years before the statements or the notices went out. And that was the only mail that we never received. We had publicly changed our address with the post office, and we received mail from every other entity associated with the county or the state, except for that notice. And it was fortunate enough that the prior owner of the property in front of me received their notice and informed me to be on the call. And I was one of the 2 participants that attended the call back in February.
Thank you, Mr. Valdez. Anybody else would like to speak?
Mr. Chairman, when others have finished speaking, I have a couple of points I'd like to raise for the board.
Okay. Is there a reason why I'm fine with you going ahead?
Okay.
Mr.
Well, I didn't want to take anybody's opportunity.
No, we'll go back.
Okay. The first thing, probably one of the most important things is the 30-day notice. There's not necessarily an issue with the fact of having that much time, but what would have to happen is the planning board would have to change their schedule in order to accommodate. So we would not be able to have monthly meetings. We would probably have to go to 6-week interims like the city of Little Rock does on their planning commission, because that would give the applicant to file a week to realize what he's got to do, a week to find it, and then send it out. So he really has limited time. He couldn't do it under our current format. And next month, in the November meeting, that's one of the issues that will be on the planning board schedule, and that is the November 22nd. I mean, the 2020 meeting schedule, along with election of officers. That'll be on the November docket. So this could coincide with that, but the 30-day notice will not work unless the planning board chooses to change its schedule. It will not be possible.
And could you explain for us? That's a really good point. How does that 6-week process work for the city?
Well, it's
Just simply need
instead of every month, the planning board would have to change their meeting schedule to every 6 weeks in order to allow somebody to file and get the notice done and get it out in time.
So instead of 12 meetings per year, we would probably have 9 or 10.
Yeah, correct. Whatever the 6 weeks allows.
Okay, that's a very good point. Thank you for the call out. Did you have something else you said?
Yes. The other thing, the non-contiguous land, I think one of the biggest problems in this sequence of events has been, in my opinion, based on what I've discovered with the ADQ and the health department, is the lack of proper notice on sewer improvement, sewer package plants, wherever they are in the whole state of Arkansas, including Plaque County, because the only thing they require is a notice in the legal ads of the papers. Virtually no one's going to know that there's a sewer package plant is being proposed in their area, whether it's adjacent or part of the situation. You see what I'm saying? So I haven't spoken to the health department ADQ, but that is what should happen, in my opinion, for all these package plants, which have turned out to be quite an issue, of course, in the city of Little Rock and the new TJ and now in unincorporated Plaque County, is that there's such a lack of notice. They're the ones that know. We don't know. We didn't know that they were proposing, or that the developer had purchased other lands or had another idea about where they would put a package plant other than the one that they originally had. So the planning staff will not likely know about a circumstance like this unless everybody knows. In that case, that would be a health department or ADEQ requirement on their notice procedure. So I think that's where the big gap occurred on this particular project, is there was just a hole in the notice requirement from the health department, number one, because like I said, it wasn't even the land area was not a part of the subdivision that we were considering. So it would be hard for us to know that there was something like that unless we stumbled across it or something else. So it's not that we would say that a non-contiguous land issue would not be notice worthy. It's just we want to make sure that we'd actually know about it in order to require the notice.
Is there a way for us to add to our checklist? I mean, that, as you described, Van, that's been what has been the case up until today. But now that we know what we know, can staff make some recommendations at the next meeting, or
we can just add it to our checklist requirements that, when we're looking at a project, to say, for them to notify us or provide us with any information regarding to any off-site improvements that may be associated with the development. And therefore, then we would know it, and we could require the notice at the, for the 6 weeks, if that's what we end up doing.
Mr. McClendon?
Yes.
Why does the notification process have to be tied to the commissioners' meetings? I don't think it has to be.
Because it would.
Why does it have to be tied?
Okay, so typically our structure works like this. The filing is like the first of the month, whatever that happens to be, the first work day of the month. And then the fourth Tuesday of that month is the actual public hearing. So there's no way that a person could file for the docket for that month and get the notice done if it was longer than the time allowed in the, between the filing and the public hearing. You have to have
Why,
time.
and why is it that, and why isn't the wastewater treatment plant part of the subdivision? Why treat it separately like that? Like in the case of Paradise Valley, it should have been part of the plat. It was separate, but why is it not part of the subdivision?
I think I'll address that. There was no subdivision of the land on which the sewer facility is situated. So the consideration of the board is designed to contemplate the taking one piece of land or other parcels of land and subdividing it into multiple other smaller parts, typically smaller parcels, or changing boundaries for parcels for the purpose of use. So that lot, as I understand it, was already a parcel across the road. It wasn't being redesigned or split. It was simply being used. Now, I don't think there's any dispute that it's a support facility for the proposal, but it's not what the body is considering for the purposes of dividing land.
Right, but just to keep us focused here and make sure that I'm tracking correctly, that makes perfect sense, but in the context of the notification,
sure.
Mr. Fogelman, there's no reason why we could not require developers to include all lands that are associated with that subdivision, so that for the purposes of notification.
Yeah, that's correct. And I'll just an observation. If your notice area is half a mile from the proposed subdivision site, I think it's pretty unlikely that you're going to have a support, I'm going to call them support facilities, but an associated or ancillary site that's not being subdivided, but is supporting that subdivision that's a half mile away. So I think the radius that you've proposed actually will accomplish the inclusion of those support facilities. It really only if you pull that radius in more closely would you probably need to expressly include those support facilities. But that's just an observation.
Okay, yeah, I kind of thought of that too, Adam, actually, and I can see that would accomplish the goal.
I have a question,
yeah.
Mr. Chairman. Is the proposal to provide these notice requirements for all subdivisions or all preliminary plats of subdivision?
Whatever is in the code. Jim Craner sent me an email on 8/25 and section 1.9D in the subdivision code. So whatever that covers there. I would say for everything, in my opinion.
Van, I'm not sure if you can quickly.
I heard it. I'm just looking to see what section says, what that particular.
Right,
says.
right.
It's the notice section for a subdivision code. I don't know that there's any other section.
What?
For subdivision, yeah. Okay.
Just a second. Well, 19D is notice for all applications that are asking for a variance from the standards in this ordinance. So if it's not asking for a variance, then there's not a notice requirement. So you have to make a distinction.
Okay, I'll make note of that.
Yeah, so there's there's preliminary plats, there's final plats, there's replats, there's lot splits, there's site plan reviews. There's also all of those things that you might want to think about if you're going to require notice and have it and decide what it is you think a notice requirement is necessary for, I guess.
Mhm. Okay, thank you.
You're welcome.
Any other discussion? Okay, Ms. Eames, unless you have further discussion on that item, we can move forward to number 2.
All right. As earlier mentioned, I live in Little Italy. I have attended several community meetings in the area with residents, including Roland and Y, and they are not happy with the high density urban development occurring in the rural parts of the county. Time and time again, people will remark that they move out into the rural area for a reason. And there is nothing in the subdivision ordinance code, as I've been told many times, to prevent, for example, leapfrog developments into areas which have no infrastructure to support it. The proposals I have seen, I've not personally been satisfied with. I have had frustrations with the subdivision ordinance, and most proposals are inconsistent with the best use of the land. I would like to see us work towards and adopt the land use plan. So according to Mr. McClendon, in an email he sent me in July, the county does not have a neighborhood plan except for the Lake Maumelle watershed zoning ordinance, nor does it have zoning county-wide. So land use is not zoning. As has been explained to me, a land use plan has no teeth on its own, but it would be married to the subdivision ordinance, which is not zoning, which we would modify that to control density through lot size. The land use could inform what max density is for areas defined. For example, we could have 5 acres for rural farmstead residential. We would develop general categories, and it could be a roadmap for the future. We would conform the subdivision code to the land use and could provide protection to certain areas. A land use plan could be done in-house depending on the complexity and may not require that much from staff. The people are requesting a simple one. Land use helps organize land uses and balances private property rights with desired community character. It is different from zoning, which divides areas into zones and dictates what activities can and cannot occur. For example, Lake Maumelle watershed zoning ordinance is zoning. So the area of Roland, Y, Little Italy are part of the remaining 4% of forested land in Pulaski County. It's located in the area of Pinnacle Mountain State Park, the Ouachita Trails. We have Lake Maumelle watershed. We have the Arkansas River Trail that sees cyclists from around the state and country. In fact, the BDB 100 and other cycling tours ride right down Roland Cutoff Road, where one of the first high density developments has been proposed called Paradise Valley, as well as its treatment plant. This board is in receipt of 2 letters from local environmental advocacy groups, the Audubon Society of Central Arkansas and Arkansas Sierra Club, who support preserving the forested areas of this part of the county. Even city dwellers escape to this area to receive refreshment. I have asked residents if they would be in favor of a land use plan being developed, and I have asked my question in several meetings in front of a full house. They seem to be in favor of a simple land use plan. So I did speak to our county attorney about this, and developing a land use plan and modifying the subdivision code to reflect the desired outcome is within our purview. It is my understanding that a land use plan would not require quorum court approval. But of course, any changes to the subdivision ordinance would. Thank you. I'm looking for input from the board and your opinions, as well as the people.
Thank you, Ms. Eames. Again, I'll remind everybody, this is discussion. I think we learned from the first item, the discussion was very productive and helpful. Open to comments from the board or attendees.
This is Dan Scheinman. May I speak?
Hello, Mr. Scheinman. Good to see
Hello.
you.
Good to see you. Yes, on behalf of Audubon Society of Central Arkansas and Audubon Delta, we support the drafting of a land use plan for Pulaski County.
Thank you, Mr. Scheinman. Anybody else?
Mr. Chairman, there's a couple of things. One, the staff is not in agreement with the idea that you can adopt a land use plan and zone from that some way through a subdivision regulation. I don't think that holds up. The investigation I've already had in my own personal experiences tells me that no, you cannot do that. Secondly, for the county to do a land use plan would require the quorum court involvement, because in order to do such a thing, you would have to obtain monies and funds to hire a consultant to do a land use plan for the entire county. Because I don't see how, I mean, unless the neighborhood out there has decided they only want zoning for their part of the county. I don't know. It just depends. Even still, it's going to require a consultant, and we're talking about significant money. We're talking about probably $500,000, I'd guess, on the front end, and that's just to have the study done, and then to have to draft some regulations based on that, and maybe hire staff and have office space to ultimately have zoning, building permit, which are required for zoning, building permit, or location permits. That's what it's going to take, and there's a conversation that can be had for sure, but it's ultimately going to take money, and it's going to have buy-in from the county judge and the quorum court.
But Mr. McClendon, I wasn't asking about zoning.
I know you.
As I understand, zoning and land use are two different things.
Correct. The zoning is based on a land use plan. The land use plan might give you an idea of how you have to have a land use study first in which to discover what the land uses are. Then you have to have a comprehensive study and review of that to develop the land use plan. Once you have a land use plan, you have to have some sort of regulation to put it into effect, unless you just like to have a plan.
Why couldn't the subdivision ordinance be modified to, because it controls density by lot size? Why can't we use the land use plan that the board could develop themselves? We could, I'm proposing that we, I would like to form a committee of the board members and with input from the community. Why can't we do a simple, very simple, what you're talking about sounds very complicated. That's not what the people want. They were wanting something very simple that I think we could do, and then simply modify the subdivision ordinance and control the uses per se with the lot sizes that stipulated in the subdivision code.
You can't control land use by a subdivision code. Land use is the land use is a sewer treatment plant that you don't care for. That's a land use. And the city of Little Rock has an extraterritorial plan and has a zoning ordinance in order to enforce that or create designations in order to know where that might go and under what conditions it might be approved. And then it has a conditional use permit section, which requires the review of a sewer package plant in order to be determined whether it's compatible or not. So the compatibility in land use plans are, residential to residential is not a compatibility issue. The density of the residential may be a compatibility issue, maybe. The density of residential development, but the density of residential development in our case is controlled more by sewer availability. because in the county, if you don't have sewer, you're going to have septic. And the health department's going to, the dictation of the lot size will be dictated by whether there's a public water supply or whether a particular piece of ground has a sewer, has a septic tank and a well, or a septic tank and a city water or approved water supply. So that's what really regulates the size of lots in the county. Because if you have a septic tank and if you have a well, then there's certain health department requirements that are going to require a certain amount of land depending on the soil density or the soil type. So we don't know what that is. So you can't just artificially put a size on it and have it work. That's more. But if you have a public water supply and you have a public or a sewer supply rather than a septic, like in this case that we're talking about, we have a public water supply and we have a private septic system. Well, that allows you to have the density or the smaller lots, which don't seem to be compatible with, or at least in some people's view, of what's out there.
I would like the county attorney to give his opinion on this, if he may.
That's fine. Mr. Fogelman, do you have?
I'll just say that there are innumerable ways to design controls, and whether you design controls based on use or based on some other factors, at the heart of land use control, for whether it's a city or a county or a state, doesn't matter who it is, it's a police power that is exercised by the government, and the end should be health, safety, welfare. That's the underlying legal authority that you've got to look to make sure that whatever the design is, some places use, and even within use, like even I think Little Rock's zoning code was adopted in like 1981. Prior to that, they had what they called a pyramidal zoning scheme, where you could, in an industrial area, you could have commercial, you could have residential if you wanted to. The less intense uses were permitted, even though the basis was use. There are some places that zone based on form, where, you know, if the street is a local street and the speed limit is 25 miles an hour, then you're set back from the building front to the property line or to the curb is a certain distance for health, safety, welfare purposes. There are ways, lots and lots of ways to approach land use controls or land development controls. Not necessarily use related, but certainly that govern development. And so it would take study. I will say this, it will take study. But there's more than one way to skin a cat, I think, is the easiest way that I know.
So Mr. Fogelman, in your opinion, I'm sorry.
Yeah, if you don't mind. I mean, what I was going to say is, not just for the purpose of time here, we are after 5 o'clock, but I'm not overly concerned about that. But I'm sensitive to it. That said, my understanding is that your intent was to ask the board and myself to form a committee. And so at this point, I would just like to ask if you'd consider this conversation to be adequate at this point, and go ahead and consider I'm perfectly open to you making a motion to form a committee so that this conversation could continue in earnest. And I think it may actually be more productive. So that the committee could consider the options, discuss with staff, and come back at the next regular session, regular board meeting, and give us a progress report.
Yes, absolutely. May I make my motion now, Mr. Chairman?
You may.
Okay, Mr. Chairman, I move that this body create an ad hoc or special committee with the purpose of drafting a report to protect the agricultural and rural areas of Pulaski County and present its recommendations no later than a date to be determined by the chairman.
Okay, the only thing absent from that is I'm going to recommend that there be 3 board members.
Okay.
I have found that on a board of 9, 5 would probably possibly even slow you down. But I think
Okay,
it would be appropriate other than, unless you have an objection to that.
No, I'll amend my motion to include 4 board members.
4, not 3.
Is that what you, 3 board members,
Yeah.
including myself?
Mhm.
So that'll be 4.
No, including yourself would be 3, unless you're,
Okay, 3, including myself.
unless you seriously objected to that. That's what my recommendation to you would be. I don't mean to strong arm you into anything. If you feel it's necessary to have 4, I just feel like for a board of 9 members, I think 3 is a considerable representation.
Yeah, I think we can be lean and mean.
Okay, okay. I have a
But I
motion.
do agree, Ms. Eanes is critical for that ad hoc committee.
Yes.
Oh, thank you.
Let me, this is Patrick Hayes. Let me ask a question. How are these 3?
Wait, I'm sorry, Mr. Hayes. Let me just stick with protocol here. I have a motion on the table. We will have opportunity for discussion, but.
Well, this is a possible amendment.
That's okay.
To the motion.
That's okay, but let's see if her motion even gets a second. Okay. And that could even be you.
I second the motion, Mr. Chairman.
Okay. Thank you, Mr. Wilson. Now, any discussion? Mr. Hayes, you have the floor.
Well, the question that I had was how are the other 2? I know there's 3 of us or 3 board members, but I would almost suggest that those who might want to volunteer and that the chairman select from those. If nobody volunteers, then the chairman, will say takes executive action and nominates the other 2.
I think that's kind of implied, is it not? Is that not your idea, Ms. Haynes?
Yes, I think so.
Okay.
I would hope that.
I don't think we need to spell it out.
Yeah.
Well, if that's fine, if it's implied, that's fine. I just, when you say the board select, then that means the board selects, at least the way I would read it. But if the chairman selects and the board confirms or whatever's implied is fine, just so we understand what's implied.
Yeah, and I don't mean to be loosey-goosey, but that's a very good point, Mr. Hayes, and we will cross that bridge if we have a number over 3 members of the board that would like to participate.
Okay.
All right. So any further discussion? All right, all in favor say aye.
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 Any opposed? Okay. So the board has approved the creation of Mrs. Eanes. I'll invite you to come up with a nifty name before our next meeting.
All right,
We
I
don't
will.
let's give it something, 2 or 3 words, please. But I would like to open up to the board for anybody that on the board that would like to serve on this committee.
I'll serve, Commissioner Ian.
Thank you.
Yeah, Mr. Chairman, I'll be happy to if there's a need for a third, or certainly defer to someone else if they'd like to.
Thank you, Mr. Hayes.
Thank you.
Anybody else?
That's the maximum, isn't it? 3?
Just wanted to make sure that we didn't leave anybody else that wanted to, and then we'd have a runoff or something.
And Mr. Chairman, the logistics of the meetings, I guess we can talk about another time, behind the scenes.
Yes, that'd be fine.
Okay. Okay.
And I will appoint you to chair that committee, Mrs. Eanes. So
Okay.
those would be the logistical discussions need to be initiated by you.
Okay.
I want to be really clear. I don't want to drag you down. Okay. You just,
Chairman, I'm sorry, one quick question. I'm assuming this subcommittee may be subject to FOI.
I assume so.
Okay.
Yeah,
I
if
just
it's
wanted
got
to,
more than one member of the board together, that's a public meeting.
Absolutely.
right. So, so I just wanted to point that out. I thought that was the case, but I thought, for the benefit of all of us that, staff or Miss Eanes, however we're going to do it, maybe it'd be good for staff to do and Miss Eanes to notify, of our meetings so that we wouldn't get on the wrong side of FOI.
Let's make sure there's proper notice.
Let's make sure there's proper.
Will do. You can count on it.
So, Mrs. Eanes, let's move on, but
Okay.
to wrap that one up, you initiate your conversation with staff.
I will.
To make sure.
Thank you. Do I need to make a motion to ask staff to provide us with information about land use plans? Do I need to make that motion, or I can just ask staff to help us?
The chair of that committee, I'm authorizing you to put in reasonable requests of staff.
Okay.
There may be a need to talk to the county judge or the county attorney. If staff reports back to me that you're asking things that are costing a lot of money or going to cause additional resources, don't hear me say that's not going to be allowed. Just hear me say that's certainly not under my purview. We don't have a purse, so we need to go to the quorum court for that.
Okay, thank you so much. And
Kathy Wells
Mrs.
here,
Wells.
President of the Coalition of Little Rock Neighborhoods. I wanted to speak briefly on the record in support of land use planning to protect rural residents from unwise and detrimental development. Y'all go, girls.
Thank you, Mrs. Wells.
thank you.
Mrs. Eanes, you had a third item?
Okay, yes, real quickly, everyone. And Adam is here to answer some questions about in September, I mentioned how confused I've been about our approval process, and was wanting to ask our county attorney about the legal shall language noted in the subdivision ordinance code, and why we approve plats before these documents as stipulated in the code are obtained. The code clearly states the word shall is mandatory, and that's in section 2B. And staff recommends on some plat checklists approval subject to complying with staff requirements. Maybe our approvals are incomplete. I don't know, but I have observed one development we approved in February, Paradise Valley, that although required documents have not been obtained by the board who gave this soft approval, I call it, subject to complying with staff requirements. An example of one document that was not received is the fire department approval letter. The developer almost immediately began clearing the land to begin construction on his own roads. Obviously, the plat cannot have been signed and certified by the director or his designee since not meeting all the conditions of the preliminary plat filing, and that's in section 3.5B4. I am concerned that this could be a violation of the code section 1.4B and section 3.5B4. Shouldn't the board have all the information documents provided with the preliminary plats as stipulated by code before this board could approve preliminary plats, and that construction of any kind should not begin until the director then signs to certify the submitted plat? So I would like to know, has the certification been made in all instances before land clearing is done? For example, in Paradise Valley, was the certification signed?
To do what you want.
It could not, if not, the preliminary plats in these cases can they be rescinded and stopped? I'm asking our staff attorney to please advise this board. Are the preliminary plats in essence incomplete with these soft approvals? And if indeed plats are not being first signed and certified, I think we have a responsibility to make sure that everything is in order according to code. So our county attorney is here to explain the language used in the subdivision and development code. And I really want to thank him for making time.
Well, thanks for the question. There's a lot there to unpack. So,
Sorry.
And along the way, you can help me with clarifying questions if you don't mind. So at the heart of the question is what is the process and what is required for approval of preliminary plats? And so the custom has been developed over time that plats that are before the Planning Commission can be approved contingent, and that approval is contingent upon satisfaction of additional requirements that may not be present at the time that the plat is in front of you. Right now, y'all meet once a month, but staff shows up every day to work. And y'all have some formalities and time restrictions. Y'all are a volunteer board. And so what that contingent approval allows for is for a developer or whatever role the person plays that's presented a subdivision plat, whether it's family member or developer or something else. I'm just going to call them developers just for the ease of simplicity. But a developer shows up, they have a preliminary plat, missing some information, missing some authorizations. They can't get final or they can't get approval of that preliminary plat until all of the conditions are met. However, they can present it to the board to make a determination if the boxes that are ready to be checked can be checked. And the body can go ahead and take a vote that is contingent upon facts that the staff can determine. And so I have no concern from a legal standpoint. I have no concern with that process, with a person coming in and presenting a plat and receiving consideration of that plat and being, it would be the verbiage of the motion would be approve. I so-and-so approve, move that we approve the preliminary plat conditioned upon providing the missing documents. And that's, I'm being a little bit inarticulate, but the missing documents would be the condition that would have to be met in order for an approval to actually occur. Your other question was about land clearing, and the county's code doesn't control, the county's subdivision code does not control land use. So if a property owner that is going to develop land, even if they don't have a subdivision approved, they can go cut trees down. Now, they may be getting ahead of themselves. The Planning Commission may say, hey, your proposed plan doesn't live up to our standards, and so we're going to require X, Y, and Z to occur in order for those standards to be met. But if a property owner wants to clear cut their land and there's nothing that there's no land use controls that stop them from clear cutting their land, then they can clear cut their land.
But if that clear cutting is because they're about to do construction work, isn't that a little different than just clear cutting your land because you want to clear cut it? But if they're clear cutting it in order to prepare for roads, for example, Is that not a little different kind of clear cutting?
Well, and really what the subdivision plan authorizes is a property owner who has an aggregated or a large piece of land or aggregated pieces of land to sell them as smaller pieces of land to other purchasers. And it's a control on conveyance as much as it is anything. If I want to go build, if I've got 5 acres and I want to put more than, well, 3 houses on it. I want to put 3 houses on it. I can go put 3 houses on a 5-acre parcel in the county, so long as I've checked all the boxes with health department and everything else. That's not subdivision. If I'm going to build, I think it's 5 or more in the county, then that's where you get into subdivision reviews, and so there is some development control, but it's not. It doesn't get to the degree of precluding somebody from cutting their land or moving dirt.
Well, the code in section 35B4, it says, subsequent to approval of the major subdivision preliminary plat by the Pulaski County Planning Board, the director of the Department of Planning and Development or their designee shall sign to certify the submitted plat if the applicant has met all requirements and conditions of the Pulaski County Planning Board and the construction of the subdivision may commence. So to me, that says, I don't know what the word construction could mean to you, but construction on roads, I think that falls under that term. So to me, I feel like, Adam, am I wrong that
Miss
we're not?
Ains, I'm sorry to interrupt, but this is carried on for over an hour with
I'm sorry, Mark,
individual questions.
you have done this to me before, and I've had about enough of
I've
this.
listened for 3 hours, Miss Ains.
Okay, you guys.
These are your individual questions. not
I'm
mine.
sorry.
No,
These
from
are not
now
my
on-
individual
okay.
questions.
Okay, no, we gotta stop that. I've allowed everybody on this conversation to have a conversation because it's worked. But from now on, you will address me directly.
Oh my gosh, I'm sorry. And I feel like
Ms.
I was
Dean, I'm not
attacked.
asking you to respond. I'm just saying.
Okay.
I've allowed
That came out of nowhere.
But so please concisely, your question to Mr. Fogelman is that the very last word there says that construction may commence. But Mr. Fogelman has already said that if a developer owns the land, he can cut the trees as he wants, as he or she wants. Mr. Fogelman,
I
is there any
was trying to
connection?
get.
I know, but let's it is getting late. We've been on here for 2.5 hours, actually 3 hours. Mr. Fogelman, is there a connection between the two?
Yeah, I'm sure at some point the preparation would go from preparation into construction. But there is a difference between land clearing and constructing a subdivision as approved by the planning commission and according to the plat that's been certified. So I mentioned this earlier. I don't particularly like to operate in hypotheticals because there's always a new fact that can come up. So those are the types of questions where my best service comes into consultation with the board and staff in a particular circumstance. If somebody is out there building roads before there is a subdivision plat that has approval, then if there is a concern raised by staff who ultimately would be responsible to carry out the plats that are approved or not by the commission, then I'm sure that I would be getting a phone call if one was needed, if consultation was needed. So yes, I'm sure that at some point preparation for construction finds its way into construction, but where that line is, I can't say sitting here today. There is case law on at what point, what is an indication of construction and for the purpose of for other purposes, for the purpose of a materialman's lien attaching and doing land clearing is not one of those things. You can clear land without a materialman's lien attaching to the dirt that will ultimately be subject to a mortgage or whatever, and for the purposes of construction. But if you dig footers for a house, then that would be earth moving for the purpose of construction, and it's a little bit different analysis, but that can actually trigger a materialman's lien attaching. And so I would say that would be closer to the thing that's prohibited if construction can't commence. Until the plat is approved.
So may I ask a question, or am I silent now?
Mrs. Eames, you were never silenced.
Okay.
This
Thank
is
you.
my meeting, and I've just asked you, I'm responsible for it, and I've just asked you
Yes.
to direct your questions to me. I did not silence you.
Okay, thank you. Mr. Chairman, I would like to ask Adam, so if we start to see roads going in at Paradise Valley, and I don't know if the preliminary plat has been certified. I can't imagine that it has. Then that is something that I should report.
Yes.
Is that correct?
Then that's, if you have a question about it, then that question should be directed. I don't know that report is the right word.
Okay, sure, yeah.
But if you aren't certain of the status, then you should absolutely inquire.
And who do I inquire with?
I would direct you to Van to have that conversation.
Okay.
Mr. Chairman, Ms. Eames and Adam, I think the answer to the question, if you had a developer who went out and cleared his land and did not have approval for a particular layout and was dumb enough to go out there and start building roads and digging trenches and trying to put easement lines in without approval, somebody should say something to him just to prevent him from hurting himself. Because what's going to happen there is whatever he may or may not be doing will ultimately come back to haunt him, because if he can't get it approved, he's going to just be spending a lot of money for nothing. And I don't think developers are in the business of spending a lot of money for nothing.
So Mr. McClendon, yes, has the preliminary plat for Paradise Valley been certified?
No.
Okay, so he should not be constructing roads
If he's smart, he shouldn't. That's correct. Because he doesn't have a road layout approved. So he would just be out there wandering around with bulldozers and asphalt for no particular reason that I could see. If he did start doing that, somebody could tell us, and I would send somebody out there and we'd advise him he probably should stop because he doesn't have approval. I mean, but he's not, unless he starts selling land, he's not done anything but mar his own land, you say.
So Mrs. Eames, let's, unless there's anything pressing, I think we need to be sensitive to the fact that we have gone over 3 hours.
Oh yes, absolutely. And I thank your indulgence, really your forbearance, the board. Thank you so much. I felt like those things were important, and I'm done. Thank you very much.
Okay. All right. Thank you. And I want to express my appreciation. As I said earlier, it's been a very productive day, but it also has been a long day. Meeting.
Mr. Chairman, if I may, I want to note that nothing that Ms. Haynes has presented today is unreasonable. I'm completely supportive of everything she's brought. Thank you.
You're welcome. Thank you, Mr. Wilson.
Thank you, Mark.
Okay, we just have 3 more items. I'm kidding. I will entertain a motion that we adjourn.
Got it. Adjourned.
All
I'll
right.
make the motion, we adjourn.
All right. So moved. And did I get it? I got a second, right?
I did.
Okay. All in favor, say aye.
Thank you, Mark.
Aye.
Aye. All right. Y'all have a great evening.
Thank you.
All right. Bye-bye.
Oh, yeah. But I want to myself.
Sure.